Welcome back. Thanks for staying on board. John McGinness with you, News Radio KFBK. Going to get your calls on the tagging issue, but I also want to roll this out. We've talked a little bit about this in the past as this has worked its way through the legislature, seeming to have failed when it couldn't get cleared the assembly. But it's the concept of virtually eliminating cash bail for people who are locked up in custody. It did fail on the assembly floor last month, but it's still alive. It has had new life actually forced into it. This is Senate Bill 10, which is Hertzberg's bill. And the concept that the proponents put forth is that the current framework of setting bail by crime and then releasing defendants who can post bail at that rate discriminates against the poor. They assert that it traps many Californians in custody long before they have even been convicted of anything. Senate Bill 10, if it becomes law, would largely eliminate the use of money bail by having courts rely instead upon the assessment of an offender's flight risk and danger to public safety. It deemed necessary bail would be set based on their ability to pay. Cash bail is what's involved here. Should you have to post a bond to be released from custody for certain offenses? Obviously, many offenses, there's no expectation, no requirement today. Most people who are arrested for DUI, for example, are cited out when they've sobered up and they can go back to living their life and then face the consequences later, and whatever comes of their trial, so be it. Well, the idea, and remember, bail is not intended to be punitive. It's not part of the punishment. It's simply a mechanism through which there is some reasonable likelihood that the defendant will show up in court as promised or prescribed. But now we have heard from the highest court in the state that there is significant concerns about this. The debate has now cleared the Senate this week, largely in its original form, and it goes back to the Assembly Public Safety Committee. The Judicial Council of California has weighed in on this for the first time, actually voicing their concern through a 6-page letter describing with the terms they use as a significant concern. The Judicial Council is the policy-making body of the California courts, chaired by the Chief Justice, Tani Cantil-Sakauye. And in her 6-page letter, she makes some very valid points, I believe. She says the Judicial Council continues to have substantial concerns about many elements of the bill, including the impact on judicial discretion and independence, the creation of unrealistic or unspecified timelines, the imposition of unrealistic responsibilities and expectations on pretrial services agencies, upon which the court would rely for information in making decisions, and the creation of an overly burdensome and complicated system. She goes on to say, just bullets throughout this, Senate Bill 10 does not establish a reasonable or realistic balance between the interest in releasing all defendants who can be safely released pretrial and a concern for public safety, parenthetically including safety of victims, and the administration of justice, parenthetically fleeing jurisdiction failure to appear. Judges have constitutional and statutory responsibility for implementing the laws in ways that ensure appropriate consideration for protecting the rights of the accused, protecting the public and victims, and providing for the fair and efficient administration of justice. She goes on to say SB 10 would require the pre-arraignment release by the pretrial services agency of any person charged with a misdemeanor, unless the defendant is already on pretrial release, without providing an opportunity for a judge to determine whether the defendant, who may be charged with a serious misdemeanor, including domestic violence, is a risk to public safety or the safety of the victim, or is likely to flee. SB 10 also does not account for those defendants who fail to appear and are cited and released rather than booked. Here's what I found even more illustrative, is a voice from an area that you might think would be inclined to appreciate the efforts of Senator Bob Hertzberg, because this is a man who represents the poor, inner city, downtrodden, oftentimes just by the nature of how things are, the ethnic minorities in Southern California. The Reverend Jesse Lee Peterson, whose L.A. organization known as BOND helps at-risk minority boys become responsible men. He says no bail system means no accountability for criminals who are being put right back into the communities where they committed their crimes in the first place. Interesting, I think, coming from his perspective on this. I find that to be very interesting. So this is, it's still alive, but I think you're hearing concerns from a very legitimate voice And I think it's entirely appropriate for the state's highest court and the leadership therein to take an active role in this. I respect the Chief Justice for speaking out and sharing her concerns, and I think it may possibly have an impact on what happens with this in the legislature. Obviously, victims' rights groups and law enforcement agencies are adamantly opposed to this, and of course the bail industry, and I respect their position completely. They do have a vested interest because it's their life's blood, but they also see how the bail system works and how critical it is to ensure that people show up in court as prescribed when they've been arrested for various violations of law. And again, it's entirely appropriate, I think, to be reminded and recognize the fact that it's never intended that bail be part of the punishment. You're still presumed innocent at the time you're arrested and not even officially, formally charged. Nonetheless, it does take a reasonable cause. That's the standard. Probable cause to believe that a crime has been committed and the person arrested is the person who has committed that crime. That needs to be articulated at the time the arrest is made in order to make it a lawful arrest. When you have met that legal threshold, then that person is to be held until they can, in some cases, be cited and released, and that does happen in the current system even, or when they can arrange to make bail, or if they're violation of law or the crime they are alleged to have committed, and there is some evidence collected to support that allegation, it indicates a reasonable likelihood of further threat to the safety of the public, especially targeted victims, then they need to post bail and ensure that they're going to show back in court. But you can send a person right back with no consequences, no burden over them to ensure that they have incentive to show up in court and face the consequences of their alleged conduct. They're entitled to due process. But when they've behaved in a certain way and that behavior has been observed and articulated in the form of a probable cause statement to make the arrest lawful, then that does put them in a different category. And the risk to the public, I think, is something that should be considered.